All right, so now, and I'll just go ahead and do this, okay? Remember, there's two categories of court cases, okay? Criminal, where a law's been broken, all right? The defendant is the accused. The prosecution tries the case for the state, okay? Now, civil case is a private dispute that seeks money and or property. Now, in this case, instead of a prosecutor, you have the plaintiff who files the suit, but the wording doesn't change for a defendant. The person who's being sued is the defendant.
So a plaintiff and a prosecutor can
They're the same thing, it's just two different types of court cases, okay? Defendant is always going to be the same. But if you see a plaintiff, then that tells you right away that's a prosecutor, or that's a civil case, okay? Now, how to read a court case. In a criminal case, the prosecutor's name comes first. In a civil case, the plaintiff's name comes first. So Marbury v. Madison, who is the prosecutor in this criminal case? Marbury. In a civil case, who's the plaintiff? Okay, Marbury, okay. So, and there too is the same, prosecutor, plaintiff, depending on the type of case, their names will always be first. Okay, everybody have it? All right, now, the jurisdictions, the court's authority to hear a case. All right. Now, in a district court, each state has at least one. They have original jurisdiction. Okay? In a court of appeals, there's 12 of them, they have appellate jurisdiction. Okay? And that'll be easy because that's appellate. The only court that has both is the Supreme Court that has both original and appellate. All right? A majority opinion is the ruling of the court. The dissenting opinion is why the minority disagrees. Okay? What we got?
No.
You good now? Okay. Now, the United States has a dual court system, which means both state and federal. All right? A president can affect the nation's policy because of the judges he appoints. Okay? The Senate Judiciary Committee will either recommend or reject. Okay. Most of the Supreme Court's cases, most of them are on appeals. Appeals. All right, good question. All right. Okay, so appellate means you have on appeals. And your clue there is going to be what?
Same root word.
Yeah, the same root word, okay? Again, that's probably Latin and stuff like that, but yeah, that's where we get the word appeal, is from appellate. All right, now the two ways that the cases can reach the Supreme Court is on appeal and a writ of certiorari, which is an order to have the case sent up. Latin, it's a dead language and stuff like that, and the only people who really use Latin are doctors, something or doctors, scientists, and lawyers. But it is the root language of a bunch of arts, like English, French, and Spanish. So a lot of times the words are, if you take a look at the Latin word, it's going to give you a hint on what it means. Remember, like habeas corpus, well, that's easy. Corpus is, what was corpus? Yeah, corpse. Okay, that's where we get the term corpse. All right. All right, now, Supreme Court can refuse to hear a case. Okay, now, if the case is accepted, both lawyers will file a brief. Okay. Interested parties can submit a friend of the court brief that is known as an amicus curiae. Okay, again, here's another one of those root words. Amicus means what? Well, how many have taken Spanish? Yeah. What's friend in Spanish? Amigo. A-M-I, right? All right. That's where they get. It's the same as in French, ami. is French, A-I-N-E-E, okay? And so again, that's one of those root words. So if you look at A-M-I, that means friend, okay? Now, each lawyer is given 30 minutes to argue their case. They can be asked questions by the judges. Time is strictly enforced, okay? Then the judges will meet in conference to discuss the case. Everybody got it? Okay. Now, you have the majority dissenting opinions. Okay. Judge with the least seniority writes the opinions. Okay. Factors, I would know at least 2 factors that can influence the judges. Okay. Know at least 2 factors that will influence the judges. Source of American law: Constitution, statutory, common. Equity, remember, equity is based on fairness. It can be used to prevent acts. Okay, an example of equity would be injunctions. Okay, law is divided into 2 main parts. You have private law or public law, and as Rachel caught on that one day, private law, what's the other term we use for it? Rachel? Civil, okay? All right, so you have civil and public, okay? Everybody have it? Okay, so civil law basically is private. Okay, deals with real property, that's land and everything attached to it. All right. Movable property is personal property, which we had it marked wrong in your notes. Okay, movable property is known as personal property. Real property is land and everything attached to it. Contracts and legal agreements, family relations, anything to do with families. Now, a tort is a wrongful act that injures person or property. Intentional tort, done with the purpose of harming or destroying. Your clue there for intentional is what? Or what's your clue? Is purpose. So intentional tells you if you have intentions, that means you meant to do it. Negligence means you failed to do something that a reasonable, careful person would do. You were negligent. Okay? Strict liability, your clue there is going to be liability. Holding someone liable even if it was not intentional or negligence. Okay, that's strict liability. In other words, in their strict liability, you're liable no matter what, if you're dealing with a dangerous product. We good? All right. Public law deals with the government. Okay. International law, relations among nations, constitutional law, yeah, we already know what that is. Okay? The whole purpose of criminal law is to protect the public. Okay?
So do we not get to the administrative?
Administrative law, it may be there, but your clue there is going to be one. Administrative, okay? Now, felonies, remember, that's punishable by imprisonment of 1 or more years. Okay? Misdemeanor usually results in a fine and less than 1 year. Okay? So felonies is a year or more. Misdemeanors are usually less than a year. Usually a fine. Now, some felonies also can have fines with them too, but usually involve jail time more than a year. Okay? Stop looking like a fish out of water. Okay? Now, first off, the procedures. Police gather evidence. Okay? Police gather evidence. This means they can question subjects, obtain a search warrant. If a suspect is booked, charges are recorded in the police register. This is where you're photographed and fingerprinted. Now, in an arraignment, this is where the judge tells the defendant the charges. He sets a date for a preliminary hearing. Yeah, this takes place in the arraignment. Let's say this is a felony. It's going to take place in the arraignment. You're not going to have this. This stuff is not going to be found at the end of misdemeanor. Okay? This stuff here, this is assuming this is all a felony from law. Okay? Misdemeanors is totally different. Because even in misdemeanors, you have the right to have a lawyer present in misdemeanors. Not just, I mean, you can get one, but misdemeanors, usually not. Okay? 9, okay. Also, where the judge sets bail, make sure you return, can be denied. Forfeit, don't return. You can release it on recognizance. Okay, you can deny bail. You can release you on your own recognizance, but that's without putting up bail. But you have to, you have to be pretty trustworthy to do that. Okay. Also, the judge makes sure that you're represented by counsel. Now, defendant may enter a plea. Not guilty is 1. Not guilty by reason of insanity is 2. Guilty is 3. And nolo contendere will not contest it. Okay? 4. That's 4. Remember, nolo contendere, what it was explained to me by a lawyer was, it's just so they can make themselves, the defendant can make themselves feel better. It's still going in, I mean, you're still going to serve the time. Okay? Now, during a preliminary hearing or a grand jury, determine if there's probable cause to believe that the defendant committed the crime. Okay. Preliminary hearing. If something's prelims, it's what? It's before, okay? So that means where they're going to determine if there's enough evidence. And what happens too is the defendant can waive his right to a preliminary hearing, which means it's just going to go straight to trial. Okay? Everybody got it? Okay, now you got a choice of trial by jury or judge. Okay, adversary system is that the truth emerges when each side presents its case. Adversary is when truth emerges when each side presents its case. Okay, the two purposes of the trial: establish the facts and find the law that applies. Find the facts and the laws that apply. A deposition is a formal interview under oath, basically preserve the witness's testimony. Okay? Pre-trial motions, an example would be change of venue. So each side can do a pre-trial, can enter in pre-trial motions. An example would be change of venue. Sometimes the defense might come in and try to enter a motion to have evidence thrown out. Then he has to show why that evidence should be thrown out. Okay, everybody got it? All right, so jury selected, candidates are questioned, can be dismissed without giving a reason. If the jury is sequestered, they're not permitted to go home. Opening statements, things that both sides hope to prove or disprove. Now, because the prosecution has the responsibility of proof, they go first. Okay? In a civil case, the plaintiff would go first. Okay? You can cross-examine each other's witnesses. They can raise objections. An objection is something that claims should not be allowed. Closing statements, summarizing the evidence or lack of evidence. Everybody got it? All right. There is no time limit to reach a verdict. Guilt must be proven beyond a reasonable doubt. Okay, there's three options. Okay, they can be guilty, they can acquit or find the person not guilty, or undecided, or what's known as a mistrial or a hung jury. Which means if it's a hung jury, they'll go back and retry the case, but with a different jury. Okay. Sentencing, that's determined by the judge, all except for what now? Which one is the jury determined? What did I say? What type of cases? Huh? No. What type of cases for sentencing? It's all, okay, this is criminal. But which one now, the Supreme Court coming to say that the jury has to decide this, that the sentence takes place? Keep going. No, keep going. It has to be heinous, but heinous because they're trying to reach what? Okay, death penalty. So in other words, for death penalty cases, the jury decides, okay? Death penalty cases, the jury decides. All others, judge decides sentencing, okay? A sentencing hearing is where the judge gives the length of the sentence and where it will be served. And type of prisons are maximum, minimum security, or in your people's cases, reformatories. Now, a prisoner can be released by serving the full sentence, or they can receive a pardon. And remember, what was a pardon? By a president or a governor, and it just basically says, okay, you're forgiven of your crimes, it never happened. Okay? Or you can be paroled, which is an early release. It's still going to be on your record, but they're going to let you go. A pardon basically will clear your record. Okay? Everybody got it?